Today we have a pro-gun story out of Connecticut? No, that can't be right. And a judge sided with a gun owner over a cop? Who writes these things? I do. I write the videos. Shout out to John Crump for getting this story out in ammo land, because without the article and the court documents to back it up, I would not have believed it. Before we get into the details, let me tell you, this story is exactly one of the reasons why I am a USCCA member. The United States Concealed Carry Association was founded to help responsibly armed Americans like you. They're committed to providing life-saving self-defense resources to help you and your family be safe, even in situations like the one in this video. When you activate your membership, you'll automatically get life-saving self-defense education, industry-leading training, plus self-defense liability insurance. Don't wait until it's too late and use my link on the screen or in the description to sign up today. Like many areas of blue state New England, Waterbury, Connecticut is, shall we say, cute. Strict gun laws make it an excellent target for crime, with crime rates 34% higher than the national average. According to Neighborhood Scout, there are 124 crimes per square mile. So, all in all, it's a great place to live and is an excellent area for your GPS to suddenly stop working, which is unfortunately what happened to one Basil Sukane in November of 2018. Full disclaimer, I honestly have no idea the right pronunciation of this guy's name, so from here on out, I'm simply going to call him the driver or the gun owner. So this guy is driving his Kia Sorento, which is a far cry from a Cadillac Escalade, through an especially seedy part of Waterbury that's known for prostitution and drugs. The GPS on his iPhone froze, so he pulled over to try and get it going again. The cop, with an also hard-to-pronounce name, Officer David Andrzejewski, hereon to be referred to as the officer, noticed the car and pulled over to initiate a traffic stop. According to the driver, the cop came over, knocked on the window, and when the driver said hi, the cop immediately started yelling at him for his license. The driver handed over his license and his gun license, which, frankly, is another reason why it's good to check out the USCCA, even if it's only for their free resources. Because, according to the USCCA, Connecticut is not a must-notify state. Nonetheless, he told the cop that he had a legally owned and carried pistol in the car with him and told the cop exactly where it was. This is important for later.
What happened next will astonish you.
The officer responded by forcibly removing him from the car, throwing him on the ground, handcuffing him, and demanding to know where he was stashing the drugs and hooker.
Not really the surprising part of the story.
The cop searched the gun owner and found drugs that were actually nitroglycerin pills for the man's heart condition, a USB drive containing photos of his late father, and $320, proving that this guy was a baller. Have you ever seen a nitro pill? I mean, maybe if the guy had the little white pills, the cop could have mistaken it for some OCs or perks or something, but this purple and white bad boy capsule right here, I mean, spitting image for crack. Am I right?
Good research, you're absolutely correct.
To the cop, this was proof that the gun owner was really a hardened criminal, or at best, a drug-snorting John, because why else would someone have $300 in their wallet? So he threw him in the back of the police car and jerked him around so he was stuck half on the floor, ran his permit, and called for backup. The gun license came back legal and valid, of course, but the cop still searched the entire car, including the trunk, while waiting for his backup. When the other cop and a sergeant arrived on scene, the officer asked them what he should write the driver up for, and according to court documents, this made the second cop laugh. The sergeant told him what to put into the computer. Eventually, the driver was released with nothing more than a traffic citation, despite the entire encounter lasting over half an hour. The money and the flash drive were never returned to him. The gun owner later filed suit, claiming his Fourth Amendment right against unlawful search and seizure had been violated. According to court records, the cop in question claimed that the traffic stop was justified by a reasonable suspicion of unlawful activity and that his treatment of the gun owner and subsequent searches and seizures were all supported by probable cause because the driver had told him there was a gun in the car. Even though it was a legally owned and carried gun, and even though the owner had told him it was in the driver's side door compartment. Which, frankly, is why many lawyers and self-defense educators will tell you not to tell the cops unless you legally have to. According to court documents, the officer claimed that until he ran the permit, he had no reason to believe that it was legal, and thus was searching the car under the assumption that the gun was illegal and that the owner was committing a felony. But he also chose to search the car after finding the gun license was, in fact, legal, which kind of throws that whole defense out the window. The cop also argued that he held qualified immunity in this case because, quote, any violated rights were not clearly established. Surprisingly, U.S. District Court Judge Janet Bond Arterton agreed that the cop's reasons for the stop in general were reasonable due to the neighborhood and the location of the car, but that the officer did not have probable cause. Not only that, but she stripped him of qualified immunity, stating that no reasonable officer could believe probable cause was present. According to the judge, Connecticut law requires there to be evidence that the gun owner was not licensed in order for the officer, under the law, to suspect the driver was committing a crime. But at no time was the officer aware of the gun and not the permit, thereby making the probable cause argument completely null and void. In essence, the judge argued, just as it is unconstitutional for an officer to assume a driver's license is invalid, it's unconstitutional to assume a firearm license is invalid. She summed it up by providing decisions from previous cases that basically say being a gun owner is not in and of itself probable cause or proof of a crime. Further, she contended that the driver gave the officer no reason to believe that he was both armed and dangerous, which would have been the only way to justify searching the car. So the driver's lawsuit against the police officer will be allowed to continue. The officer has, of course, filed an appeal. What's especially interesting about this case, though, as New York criminal attorney Peter Howard Tillum points out, it's likely the case will be reviewed by the Second Circuit Court of Appeals, and thus, whatever is ultimately decided will also become part of case law in New York, as New York and Connecticut are part of the same circuit.
Oh, snap!
And as a little bonus, in the brief the officer put forward, he and his lawyers didn't even spell the gun owner's name right, which is kind of funny. Because the case can go forward, discovery can be required, meaning body cam footage, radio logs, etc. All things that typically police departments will try to settle outside of court for taxpayer dollars rather than submit to the courts. But even if the department does attempt to settle, this decision is certainly a win for police accountability and gun rights. That's your Second Amendment news for the day, guys and gals. Please give a like, share, comment, whatever, for the algorithms. If you'd like to do even more to help support the channel, you can check out any of the partners down in the description, or the support options like Patreon, Subscribestar, and PayPal. As always, thanks for watching, stay safe, and happy shooting.